Debate number one. On the other side, viewers, nearly 7 years after Ayodhya verdict reshaped India's civilizational discourse, the Madhya Pradesh High Court has now declared the disputed Bhojshala Complex in Dhar to be a Hindu temple. Relying on the ASI survey and historical findings, the court has ended the 2-decade-old arrangement allowing Friday namaz at the site, permitted Hindu worship and suggested that alternate land may be provided for a mosque as well. But even before the verdict has settled, the politics has begun, almost as a default response. AIMIM chief Asaduddin Owaisi has invoked the Babri analogy as Congress questions the relevance of the Places of Worship Act. The question is simple. When courts rely on evidence, archaeology and law, why are verdicts involving Hindu rights immediately painted as communal?
ये एब्सर्ड जजमेंट भी है, एरोनियस जजमेंट भी है। ये जजमेंट कॉन्स्टिट्यूशनल वैल्यूज के मुताबिक नहीं है।
जितनी मस्जिदें तोड़नी है एक साथ तोड़ दीजिए, बना लीजिए मंदिर, लेकिन ये हर रोज जो नफरत आप हिंदू मुस्लिम फैला रहे हैं इसको बंद कर दीजिए।
इस फैसले के खिलाफ हम अपील करेंगे, हम इसको चैलेंज करेंगे। भारत के तमाम मुसलमान इसको मस्जिद मानते हैं।
You're watching the News Hour at 9, debate number 2 on Times Now, Super Prime Time.
Thank you very much for joining me. Vishnu Shankar Jain, senior advocate. Also joining the show tonight is Atikur Rahman, Islamic scholar. And we once again have a verdict from the High Court of Indore giving the freedom for continued worship and claiming that a temple had been destroyed. Vishnu Shankar Jain, let me first ask you, what happens to the Places of Worship Act, which is in court, and in the meanwhile there is a spate of these judgments, and once again the political objections have started pouring in thick and fast. How do you look at this Bhojshala case as being another watershed case after Ayodhya?
See, definitely we have to understand first the scope and ambit of Places of Worship Act 1991. We have to understand that the Places of Worship Act will not be governed as explained by the barristers. We have to understand that what is written in the Act. And let me quote Section 4, Subclause 3, Subclause A, wherein it is held that Places of Worship Act will not be attracted to those places which are governed by the ASI Act 1904 or ASI Act 1958. So the Act itself says it is not applicable. So if Act is saying it is not applicable to ASI protected monuments, how can it be applied is the first question which I ask myself. The second most important point is that as per Section 16 of the Ancient Monuments and Preservation Act 1958, the mandate, the statutory duty of the ASI is that if any place is a shrine or place of worship, ASI will not do anything which is inconsistent with its character. And therefore, to ascertain the true nature and character of Bhojshala, the Honorable Indore bench in its wisdom had directed a survey of ASI, which is a scientific body, and the ASI in compliance of the orders passed by the Indore High Court as well as in compliance of the orders passed by the Honorable Supreme Court, conducted survey of 98 days. And the report running into 2100 pages was submitted before the High Court. And today the Honorable Indore High Court has held that on the basis of ASI report that this entire area, the premises in question, the religious character is that of Ma Saraswati Temple, is that of a Hindu temple. So therefore, Navika, we must understand that in Ram Mandir case, we were talking about how much back we will go into history. But today, through legal innovation, Ram Mandir was a case of Babri demolishing in 1528. This is a case of 10th and 11th century. Today, the monument which was standing in 10th and 11th century, we have been able to reclaim.
So, Atikur Rahman, if ASI protected monuments were not to be touched, number one, why were they touched? Why was the use changed is a question that has been raised. And this is something, that the court has given a verdict on. Of course, it is the High Court. The matter can go to the Supreme Court. But to make this once again a community versus community fight, how right is it? Is it a legal issue or a faith issue?
Well, Navika ji, as far as your last words goes, legality or the faith counts, we have seen in the Supreme Court in the last, couple of days, how the Supreme Court and the 9 judges are, they seem to be, worried what should be done with this faith versus legal argument. Anyhow, I respect Mr. Vishnu Shankar Jain. I have a question to him. He says that Section 4 does not, bars that this judgment is very much correct. May I ask you, Mr. Vishnu Shankar Jain, then that why, when the Ayodhya judgment was coming and the honorable justices were assuring and reassuring the people of India that this will be the last straw of communal disharmony, and after this every communal, every temple row will be solved. We, Navika ji, had a sigh of relief with the Ayodhya judgment that okay, what has been done by the Supreme Court in the interest of the people, in the interest of the development of India, this will be a full stop. Was the Supreme Court and the honorable justices at that moment fooling us? Fooling the people of India? They were giving some lollipops to us, and that lollipop is over now. Again the two.
Well, but Atikur Rahman, I understand your emotions. I understand your emotions, but issues of law cannot be settled on emotions. The Supreme Court order of Ayodhya did not debar anybody from raising legal questions. But fair question from a point of view of how much confrontation is enough confrontation, Vishnu Shankar Jain. Please respond to the fears expressed by Atikur Rahman ji.
First, I want to ask my brother, Mr. Atikur Rahman, that which para of the Ayodhya judgment uses the word and the terminology which he has used on the channel. He is wrongly quoting the Supreme Court of India. Where is it written, sir, that this is the last battle, after this no lawsuits will be filed? Please tell me, which is the paragraph? What are you saying on a national television? Point number 1. Point number 2, you must understand that the Supreme Court, so far as Ayodhya verdict is concerned, was only deciding a title suit, a civil dispute. And in Places of Worship Act 1991, Section 5, the Ayodhya verdict is out of the purview of Places of Worship Act. So, Atikur Rahman, a very senior person, a very respected person, can come on a live channel and say that Supreme Court was fooling us, lollipop, this, that. I'm sorry. You are talking about the highest court of the country, and you have no right or authority under law to use this platform for your water boundary. Point number 1. Point number 2, you have to understand that this present case has been decided on strong legal facts. The first important fact is that, Navika, we have given clinching evidence before the court that from 10th, 11th century, this place was established by Raja Bhoj. This is Ma Saraswati Ma Vag Devi's temple. The original idol is still existing in the British Museum in London, which the court has also directed that governments must take efforts to bring it back. The second most important point is that ASI has given a very conclusive report that all the pillars and pilasters which are existing at the site in question is that of a Hindu temple. All the Hindu deities, all the Hindu Devi Devtas, Om Saraswati Namaz, Saraswati Sadan, Lord Ganesh, everything has been found from the site in question. So this entire civilization was running from pillar to post from past 1,000 years to get back its glory, and today is the day. I want to ask a question to Mr. Atikur Rahman. Under what right you had the right to demolish my temple and offer namaz there? Does Islam permit so?
Atikur Rahman didn't demolish it. It was the invaders of the past. But Atikur Rahman, please respond to Vishnu Shankar Jain.
Navika, that's the whole problem. Atikur Rahman demolished that. Are Vishnu Shankar ji, if at this particular moment any of the Muslims must have done that, I would have been a party with you in the Supreme Court or the MP High Court.
You are standing with the act of demolition.
This is the crux of the problem. Please don't. Please.
Okay. Yes. Atikur Rahman.
No, I did not say that you demolished it. I said that invaders demolished it.
So the invaders did that. That's why, Navika ji, the 1947, the full stop in the Places of Worship Act does count a very, very heavy say in this matter. That on 15th August 1947, whichever temples and mosques, whichever places of worship as they existed on that day of our freedom will be solved. It will be a full stop. People like Mr. Vishnu Shankar Jain won't be allowed to fight the Hindus and Muslims. He wants to make the Muslims and Hindus fight. He wants the Supreme Court and the courts in India to just,
Atikur Rahman Saab, 1 minute. Atikur Rahman Saab, well, the judgment of the Places of Worship Act itself under section 4(3) of this act says that monuments governed by the 1958 Act are excluded from its operation. So the 1991 Act does not apply to it. So that argument is fallacious. The question that you're trying to make, that invaders did this, we did not. My friend, that is the whole legal battle. That if invaders have destroyed something that is part of India's civilization, history has to be set right. What's wrong with that?
No, Navika ji, no. Navika ji, if you are mentioning section 4, the ASI regulated monuments, that's my question then. Your interpretation is different and my interpretation and the interpretation given in the Ram Temple issue in the Supreme Court was very much different. If this was true, then why did every time at every day in the hearings on the Ayodhya judgment, the Honorable Justice were mentioning Places of Worship Act to be a very, very rightful legislation passed by the Parliament of India, so that these controversies end for all times to come.
Well, you know, Mr. Atikur Rahman, there are legal remedies still available. This is a High Court judgment. But the problem is that even the law, even the judgments are quoted selectively, which is why this becomes an emotional fight rather than a legal and logical fight. I don't know how legalities can be resolved through emotions, but for now, this is the judgment from the High Court in Indore. Ma Saraswati Temple at Bhojshala has got the clearance of the court. Clearly, the matter for today is a victory. For tomorrow is another port of call at the Supreme Court of India. What happens then? We'll wait and watch. Thank you very much, Atikur Rahman, and thank you, Vishnu Shankar Jain, for joining me on the News Hour tonight. With that, it's a wrap. Good night. Be safe. Have a safe weekend. I'll be back on Monday with the News Hour at 9.